Hello, welcome to the first quarter report for 2009 for California workers' compensation. The community is in an uproar and has girded their loins for the fight of the century. Two new decisions have come down in California workers' comp, the Almarez decision and the Guzman decision, as well as another decision called Ogilvie that have turned the community on its head. The governor is fighting back and putting pressure on his administration, administrators that he appointed himself, the Workers' Compensation Appeals Board, which is a quasi-statewide Supreme Court of workers' compensation, if you will. All of those members were appointed by the governor, I believe except for one. And he is putting, in his administration, a lot of pressure on these judges to overturn the Almarez-Guzman decisions. Well, what is the fight about? The fight is about power. The fight in California workers' compensation is about power. I often tell clients, and I would counsel anyone who asked, that workers' compensation, not unlike the law in general, is not about truth or justice. It's not even about fairness or equity. It's not even really about honesty. It's really about what you can prove using evidence, which in a workers' compensation case is medical reports and the injured worker's testimony, and sometimes the testimony of witnesses, to prove a case according to the rules of court, which would be the California Evidence Code and the California Code of Civil Procedure and some workers' compensation regulations. So oftentimes the truth does come out in a trial, but more often than not, whatever happens in a trial or the ultimate decision in a workers' compensation case has nothing to do with the truth. It has to do with whatever the parties can prove in their case. And those things are not the same thing. As we see nationally with business leaders, people who run companies, Bernie Madoff scandal, there are many people who have gone awry of the law and taken advantage of our financial deregulation to commit many crimes. AIG, a large company in the United States, took money for reinsurance of policies on home loans and then did not reserve or save that money they took for those reinsurance policies, and instead spent that money in the stock market, lost it with the market going down, and then had no money to pay on those reinsurance policies when they came due. But what has happened to Mr. Madoff? He was sent home with his scandal on home house arrest while he mailed millions of dollars worth of jewelry and personal possessions out of his home to family members and friends to hide them. And what has happened to the people who run AIG? People who did not reserve the monies the way they were supposed to? Nothing, except for they've got bailed out by the American taxpayer. Well, as you know, if you've ever had driving under the influence, you've ever had any dealings with the law and criminal law, as some of our clients do, they are treated much more harshly and have spent much more time in jail than any of these people have. And that's why I always tell people the law is not about truth or justice. It's largely about power and money. How does this apply to the first quarter of California workers' compensation? Well, the Almarez and Guzman decisions say that we are now allowed in California workers' compensation to go outside the American Medical Association guidelines that were put in place by Governor Schwarzenegger's reform on 4/19/04 in Senate Bill 899. We are allowed to go outside those guides if the result of the rating of the guides is unfair, unjust, or doesn't accurately reflect the injured worker's loss of ability to earn in the open labor market or future earning capacity. So just as we were able to rebut the old schedule of permanent disability. We call it the Permanent Disability Rating Schedule, PDRS. The pre-1105 PDRS was rebuttable for the same reasons. Well, the court in Almarez and Guzman has reasoned that just like the old schedule was rebuttable, the new schedule is rebuttable. And we can go outside of those guidelines. Insurance companies are now screaming bloody murder. They're screaming the fight of the century. They're screaming like Chicken Little that the sky is falling or will soon fall. This year in California workers' compensation, the Workers' Compensation Insurance Bureau, Rating Bureau, WCRIB, announced or proposed, recommended a 24% increase in California workers' compensation premiums for employers. The whole point of Arnold's reform was to reduce costs because premiums were skyrocketing. It has served to reduce costs on the backs of injured workers by taking away their disability and their medical treatment for the ensuing 5 years. But now that medical costs are rising nationally, President Obama has sought to a national health care policy or universal health care for all Americans for this reason. And that cost is driving costs in the workers' compensation system. There have been recommendations and studies done by the WCIRB already and other government organizations that the increase to California workers' compensation costs due to the new Almarez and Guzman decisions, which allow people to go outside the schedule, or even Ogilvie, which allows us to increase the rating using a mathematical formula, that increase in cost due to those decisions is only 7%. So if premiums just went up 24%, it wasn't because of these decisions. Even by the government's own admission, the cost went up because medical costs are rising nationally, and whatever happens nationally affects us here in California. So the insurance companies will now, I'm sure, put on campaigns, advertising campaigns, and put pressure on the public, raising the issue of injured worker fraud again. Whenever insurance companies have to pay money in California in the workers' compensation system, their answer is always to push up the hype on employee fraud and claim that it's all because of fraudulent employees that these costs are rising, ignoring the real realities. So we will see more of that in the coming months. We have seen or will see more pressure by the governor and his administration on workers' compensation judges, specifically the judges at the Workers' Compensation Appeals Board in San Francisco, which is the quote-unquote Supreme Court of workers' compensation courts in California. There will be increased pressure on those judges or commissioners to overturn the Almarez and Guzman decisions. In fact, in keeping with that, John Duncan has a director with the DIR, Department of Industrial Relations and Workers' Compensation Appeals Board, has already asked in his capacity of director of the Uninsured Employers Benefit Trust Fund and the Subsequent Injuries Fund that the WCAB vacate the Almarez and Guzman decisions, thereby overturning them and making them no longer the law in California. We do not believe, as representatives of injured workers or members and supporters of the National Organization of Injured Workers, we do not believe that such an action is appropriate, that the governor and his administration should let the courts take care of these decisions and not put outside pressure on these justices. But again, the law is not about truth or fairness. It's about politics and power. And the governor is going to use everything he can to put pressure to, quote unquote, save his reform, which was the biggest fraud of workers' compensation reform, as we always say on the show, is the governor himself and his reform was the biggest fraud, not injured worker fraud. As we've said on the show many, many times, the insurance commissioner at the time said employee fraud was less than 1% of the system. So a whole system was reformed, according to Arnold, for less than 1% of the workers. Now we are seeing that that is not true, just like his promise to never raise taxes and to never raise the triple vehicle licensing fee in California, which was really not raising it. It was putting it back to where it was before it was reduced because of a budget surplus. Now we've seen he's reneged on all of that, or lied, or made politically convenient decisions, and we know that's a fraud, just like his workers' compensation reform was a fraud. Well, nuts and bolts, what happens with the Almarez and Guzman decisions for an injured worker, or even the Ogilvie decision? Well, first, those decisions, at least in Almarez, because the injured worker was the person who appealed to the Workers' Compensation Appeals Board in that case, the employer is what we call, or the insurance carrier is newly aggrieved, meaning they have been harmed, quote unquote, for the first time in the case. So as a result, they have appealed to the WCAB for what's called a petition of reconsideration. And that's why the governor, his administration, the DIR itself, is putting pressure on the WCAB to overturn their decision, because they have a chance for this to happen. Well, you say, in reality, judges don't overturn decisions just because the governor tells them to, or because they're not politically expedient. Well, I would beg to differ with you. I printed for today a list of cases that came out as enbanc cases, meaning every judge at the Workers' Compensation Appeals Board in San Francisco signed those decisions. The administration came out with decisions in Pendergrass and Baglioni, en banc decisions that favored injured workers in their interpretation of the law at that time. Well, right after, that was in January 2007, January 24th, 2007 to be exact. Well, the governor at that time appointed a new commissioner, and I won't say his name on this show, but suffice it to say that you could check the appointment listings for the WCAB in California and see who was appointed after that decision came down. And then as soon as the governor appointed a new person of his choosing in April 6, 2007, the board totally reversed course and reversed themselves on both of those decisions. So we have had a situation in California workers' comp, not in the far and distant past, but in the last, year and a half, where the court, under pressure for the administration, under new appointments for the administration, has totally reversed itself on an issue at the governor's behest. Again, the law is not about truth or justice. It's about power and it's about control. So the court is now getting pressure in the political infighting in the administration itself. The acting director of the Workers' Compensation Appeals Board and DIR has been, she stepped down and she has quit or removed herself, Carrie Nevins. It has been speculated that Miss Nevins walked away because she was a true believer in Arnold's reform. She had bought the administration's, what I call, falsity or lie or fraud, that the reform was really about making things more objective or fair, and that she was trying to enforce that fairness and that objectivity. But now that she realizes, after she didn't get appointed as a full-time position, as that appointment was blocked on a permanent or appointment basis for a term, was blocked by the Senate Industrial Relations Committee by pro-injured worker senators, specifically Senator Don Parada. She has stepped away from that job because she can no longer stomach enforcing the governor's reform when it is clear now that the only fraud that the reform had to do with the reform was the reform itself, that it was a fraud of the injured workers of California and has severely harmed them. We have talked about in the past on this show how injured workers, again, for carpal tunnel syndrome, for example, get 3% if they have surgery. If they have no surgery for their carpal tunnel, they get no benefits at all. There are ways around that that doctors can measure with motor nerve and sensory nerve studies, the muscles in the forearm and nerves in the forearm, and increase some of those ratings. But as a general rule, many doctors write that if you don't have surgery, you get 0, and you get 3% if you do. Well, if you've lost your job in California because you can no longer do it, and you've been determined a qualified injured worker, and you only get 3% or 0% for your disability that caused you to lose your job, I would submit that you would think that was unfair. I would submit that that is unjust. I would submit that you would probably even think it was illegal, but you would have to take up that with Mr. Schwarzenegger. So a lot of these injuries now will be able to be receive analysis when they are unfair or unjust, or they don't match, the rating doesn't match the reality of the actual future earning capacity loss of the injured worker. As a reminder, our old system was measured in inability to compete in the open labor market, and our new system is about impairment or your harm of how that impairment affects your ability to have future earning capacity. Is your ability to earn in the future diminished? So you will now be able to consider these things, and if it's determined that the rating is unfair, unjust, or just doesn't pass the smell test by the very fact, the facial challenge, that you lost your job and you're getting very little disability, then you are able now to go outside of the American Medical Association guides. Doctors, injured worker groups, California Applicants Attorneys Association, the defense attorney groups, and insurance defense community have all been giving seminars on how can we come up with new ratings, what is the criteria, and when are you allowed out of the AMA schedule. There are people who would like to now order functional capacity evaluations in every case, have a job counselor, an old vocational expert, come in and look at the impact of your functional limitations on your activities of daily living, or ADLs, and how those functional limitations impact your ADLs, and how that translates to what kind of jobs and what kind of exertional limitations you're going to have to be able to seek jobs, and what percentage of the jobs are left in the open labor market for you. That is an expensive and lengthy process that should be reserved, in my opinion, for the cases that deserve it most. The case of somebody with a failed back surgery or several failed back surgeries, where they're getting, under the new system of AMA, maybe 30% or 20% disability under the diagnosis-related estimate method, DRE method, category 3 or 4. Those people have lost their jobs, oftentimes $50 an hour jobs with pensions, with benefits, and now that they can't use their body to work, they're never going to have those jobs again. Though that analysis should be reserved for those cases. Well, what about the back injury where you don't have surgery, or maybe you have surgery and it goes fairly well, but you've lost maybe half of your ability to lift, half your ability to bend. In the old days, that could be within a 30 to 50% disability, somewhere between $25,000 and maybe $48,000 under the old rules. That wasn't a lot of money, but it was more fair than receiving $20,000 now under the new system for that type of injury, or maybe even $10,000. Well, for those injuries, I would submit that we can now analogize within the guides, and a lot of these seminars are not now talking about analogies within the guides. So what does that mean? That means that a doctor, for instance, could say that even though the back rating criteria gives you 13% for this injury, because of the functional limitation that you've lost half of your ability to lift and half of your ability to bend, that's more analogous to a 30% rating under the hernia guidelines in the AMA book, and therefore you could have that rating. And then that 30% could be adjusted for your age and occupation. And depending if you're over 35, that money could then be, or that percentage could be adjusted to maybe 40%. And under the new schedule, that could be $40,000 or more. And that's more in line with the old system. And even though it's not fair, if you're the person who got hurt, it's fair according to California workers' compensation. And it's much more fair than a straight rating of the AMA guides. Well, the administration and the insurance defense industry doesn't want this to happen. They're going to, again, tell employers that their premiums are going to go up, even though their own state study says these decisions will only raise the premiums by 7%. So we need to be aware of the advertising campaign that's coming and the pressure that's going to be put upon the people of California to believe a pack of lies from a governor again. The Ogilvie decision is a little more complicated. All of these decisions are about 50 pages long. The Ogilvie decision basically says that the FEC rank, or the future earning capacity rank for specific groups of jobs, can be rebutted with a mathematical formula. So you can take an AMA percentage, whether by straight rating, using the guides, or analogy using the guides, or an expert's percentage based on loss of ability to earn in the labor market. You can take that percentage and plug it into the Ogilvie formula, and that can be adjusted. At a recent seminar last Saturday, the California Applicants Attorneys Association presented materials and a formula that shows that Ogilvie would serve to increase cases significantly, maybe sometimes almost by 50% or more, depending on the injured worker's situation. The insurance industry hasn't worried too much about Ogilvie thus far, and that worries me for the future of the Ogilvie decision. At the California Applicants Attorneys Association conference in January in San Diego, we heard a John Burton, an economist for presidents since Nixon, and an advisor on national workers' compensation issues, speak. And that economist said that we had to be very careful with the Ogilvie decision and the formula for workers' compensation in California in general, because the insurance industry was now trying to include temporary disability and state disability through EDD as part of your earnings. Ogilvie says you measure an injured worker's earnings in the 3 years after their injury. Well, most injured workers have no earnings in the 3 years after their injury. They may have 2 years of temporary disability, and they may even have another year of state disability after that, but they don't have earnings, or they maybe have a year of earnings after their TD ran out, because a lot of injured workers don't take the advice of the National Organization of Injured Workers for the state of California cases, that you need to apply for state disability immediately when you get hurt. Then you have them reserve or hold that claim or those monies while you're receiving comp. Then when there's a dispute in the comp system and you're not getting paid, you can receive the state disability monies from EDD at max value. EDD calculates your benefit at the last year and a half or last 6 quarters. And if you didn't apply until after you were on temporary disability for 2 years, you would have a bunch of 0 quarters. So you would get a minimum amount, which might be $140 a week or something like that, and it wouldn't be enough to live on. Temporary disability is 2/3 your average weekly wage subject to a cap, and you don't want, in EDDs paid at basically the same rate, but you don't want to go from whatever that number is for your earnings to $140 a week. So you want to apply immediately. So for those who did, you could hypothetically get temporary disability for 2 years past your injury. For injuries after 1/105, temporary disability is limited to a 2-year cap. Even if you've had back surgery again at month 25, at 2 years and 1 month, because you've had 3 and they've failed, or you have a hip replacement because your 3 knee surgeries have failed, or knee replacement, sorry, or you have hip replacement because your 3 hip replacements have failed, or hip surgeries have failed, you would not get temporary disability again in California workers' comp. So it's imperative that you lock in the highest possible rate for your EDD. But be that as it may, that would give you another year. That would give you 3 years. Well, technically, you had no earnings. Those were non-taxable wage replacement benefits paid to you because you were hurt and you weren't able to work. Well, this economist warned us that nationally, the insurance defense community, insurance companies, are pushing to have temporary disability and EDD benefits, state disability insurance benefits, put under the category of earnings. So then you would have no wage loss for 3 years following your injury. So you would never be able to prove an increase of your disability under the Ogilvie math formula because you had no loss. Well, technically it's more complicated than that because those benefits are paid at 2/3 your earnings, so you would have a 1/3 loss there anyway. But because PD benefits are paid to only replace about that much of your future permanent disability benefits, are paid at about 2/3 to replace future earnings, there would be no loss in those situations. So it's imperative that we watch out that those things are not considered part of the calculations for a new permanent disability rating schedule. I see that the proposed permanent disability rating schedule for 2008 was scrapped. Now it's being proposed as a 2009 revision of the permanent disability rating schedule. I don't know if the calculation for the 2009 rating schedule includes the temporary disability and state disability issues as income. If it does, that may kill the Ogilvie formula. So Ogilvie is an important way, complicated but important way to increase workers' compensation disability awards at this time. It may or may not be in the future if there's a new permanent disability rating schedule adopted in 2010. Remember, Senate Bill 899 required by law, it was written inside the new law, that the schedule needed to be rewritten every 5 years. So that is coming up this year, thus the new proposed schedule. So that will be something to watch out for. As a general rule, injured workers have been far behind the curve in making deals and negotiating changes since the reform with the defense industry. The defense industry has had this mapped out as a 20-year plan for a long time. They used the perfect storm of Arnold being elected governor of California and his popularity to get things that they had wanted done for decades done in California in the workers' compensation insurance industry. And they are not going to let go of those gains willingly or easily. And because of that, because they're putting this plan in place, they are several chess moves ahead, if you will, of injured workers in figuring out what these changes and tweaks to the system mean. And oftentimes they can hoodwink the injured worker advocates in negotiations because they are so far ahead in the thought process of what these little changes might mean. So you may hear it first here that Ogilvie may be dead when the new schedule comes out because it's going to include temporary disability and state disability. And if that happens, I think that would be a terrible injustice to the workers of California that injured worker groups should not agree to such a deal, and we should fight any disability schedule that goes down that road. So in looking at California workers' compensation for the first quarter of 2009, we have 2 new decisions that have turned the system on its head that allow us out of the new restrictive guidelines of the American Medical Association. Those are Almarez and Guzman. The insurance companies in the defense community is calling this the fight of the century. Former insurance commissioner John Garamendi has weighed in. There are people within the Department of Industrial Relations, specifically Mr. Duncan, who have already publicly put pressure by an open letter to the WCAB to overturn the Almarez and Guzman decisions. We have a governor who is putting pressure on his appointees to overturn those decisions. We have an acting administrative director who has walked away or quit, left her post, either because she wasn't appointed in that post or that appointment wasn't ratified by the State Senate Department of Industrial Relations Committee, or because she no longer had a stomach for pushing Arnold's reform, which now, to anybody familiar with the industry, can clearly be seen as a fraud on the people of California. So we have a very fluid industry right now that's in flux. What does that mean for injured workers with specific cases at this time? It means a couple things. It means that if your attorney didn't push to get your case settled and get you screwed under the AMA guidelines since 2005, that he or she did you a favor, whether it was on purpose or whether it was by accident. Not having your case settled at this time, especially if you lost your job, could mean a significant increase in benefits to you. Does that mean that you should now rush out and get your case settled, or you should continue to wait? That's hard to tell in California because the law can change. The case has already been appealed to the WCAB, at least with Almarez. I've given you an example so far on the show with Baglioni and Pendergrass decisions where the WCAB, after a new commissioner was appointed from the defense industry, magically 4 months later reversed themselves on those decisions. So there is political gamesmanship within the courts that happens, and so that decision could be reversed. Alternatively, the Guzman decision a writ has been filed by the Bradford and Bartell defense firm with the Court of Appeal, and so that has been taken outside of the comp system. So there's a possibility that decision could be overturned. The district court, I believe it's Bakersfield, so the state district court that will be deciding the Guzman decision has not been friendly to injured workers, has been very conservative, and has consistently interpreted things in favor of the Schwarzenegger administration. So that may not bode well for injured workers. On a bright spot, the courts of appeal have continually stated that legally they don't like to overturn enbanc decisions. In other words, decisions where every commissioner signed off on them because they consider the WCAB, or the Supreme Court of Comp in California, to be the experts, and as the experts, they don't like to overturn those decisions. Now, again, just like the WCAB reversed themselves in 4 months on the Pendergrass and Baglioni decisions, it's entirely possible that the Court of Appeal will just throw that bit of reasoning away and say, oh, we didn't really mean that, or it's different in this case because we want to take advantage of injured workers again. That could happen, but if they stick to what they've alleged so far, then that could bode well for injured workers. So if you hurry to get your case done before these decisions are overturned, they are good law, and you could maybe benefit from that. But before you pick up the phone and call your attorney or start screaming for your attorney to get this done, think about the situation at the Oakland Workers' Compensation Appeals Board, where most of my practice is. I cover the boards from San Jose, Stockton, San Francisco, and Oakland. Every once in a while, a Sacramento case. I even have one in Van Nuys, but 90% of my work is at the Oakland board. At Oakland, we just had a meeting with the presiding judge last week. In that meeting, we were told that due to the new paperless system, where the administration chose for us to do the paperwork in our offices. There's a lot more forms that need to be filled out now, so the administration can gather data from our forms and keep statistics. We send that in to the board statewide, and then the boards scan that paperwork, and that's how they process the paperwork. Well, the problem with them doing that is they've put the burden of the work in scanning the information on themselves. Well, what does that mean for people at Oakland? Well, last week we were told that because of that process, Oakland is just now completing paperwork or scanning or processing paperwork from October 2008. So if you're an injured worker who was denied a knee brace, denied an injection in your back, denied a weight loss program because you're too heavy to fit in an MRI machine, denied psychotropic medication, denied a rating outside of the strict interpretation of the AMA guides, and now you want to go outside of it and get a better rating under Almarez and Guzman, even if you file for a hearing today, you will not get a hearing probably until the end of the year, because they are still processing material from October 2008, 6 months behind. So I have injured workers who have been waiting for hearings to get their rights enforced in medical treatment since October 2008. I'm sure some people will jump in front of them and be sped through the system. But just for an example, at the Oakland board, it would be very difficult if everybody rushed in to get a decision on an Almarez or Guzman report real quick, going outside the guides to increase their disability. So that may not be possible. It may be possible at your particular board. I know in San Jose, cases are often set within 2 weeks of filing, which gives the defense a huge advantage, especially against injured workers who are what we call in pro per or represent themselves, because the insurance attorney can ask for a hearing and get a hearing very quickly before the unrepresented injured worker can even figure out what he or she is doing or what the request for hearing means or what they need to do to combat it, and they can be in court 2 weeks later having the screws put to them. And no matter how much a judge tries to protect that person, they may or may not be able to under the rules. So it could depend statewide what board your case is filed at. Venue is based on where the county you live in, the county where your injury happened, and the county where your attorney's office is. Oftentimes, if a case is if an attempt to move the case based on the county where your attorney's office is made, the insurance companies and the employers fight that motion for change of venue. Because they say it's farther away for them, they need to bring witnesses, it's outside the county where their business is, and so that's an undue hardship, and so therefore we can't move it. So venue is mostly based for that reason on where the county where you live, the county where your injury happened. So you may be stuck in whatever county this is, and that county may be processing paperwork fast. It may not, like Oakland, which serves Alameda, Contra Costa, and half Solano counties, because the administration closed down the Workers' Compensation Appeals Board in Walnut Creek. And so if you live in one of those 3 counties, you may not have a choice to move forward quickly. So this will be a very interesting situation. It is impacted, as always, by national politics and by money. The budget for the workers' compensation system in California is user funded. It comes from premiums on employers, surcharges on insurance company or insurance premiums, and so we have our own funding. Unfortunately, the governor took that money during the budget crisis, appropriated it into the budget to help California balance its budget, and so the Workers' Compensation Appeal Board that is supposed to be user funding doesn't have any money. What has that caused? Well, it's caused furloughs statewide of employees. The Workers' Compensation Appeals Board employees are subject to the furlough. That means they get a 10% pay cut, and they get the first and third Friday of every month off. This has also, by the way, happened to the people at EDD, the Employment Development Department, which we call that's where you get your unemployment or your state disability insurance, SDI benefits. And so now the injured workers and people are being laid off. I think the last statistics in the state is we're now up to 10% unemployment. At record rates, they can't process the applications at EDD. They can't process your paperwork for you to get a hearing at workers' compensation because they're off 2 days a week or 2 days a month, and so they're further behind in their work. They're already 6 months behind, as we talked about at Oakland. Workers are disgruntled. I don't know how you would feel if your employer came in and said, because we feel like it today, we're cutting your salary by 10% and sending you home 2 days a month. You probably wouldn't like that if you're a normal person, especially if you have your finances budgeted and every dollar accounted for. That would make it very difficult for you to change your life and to cut things out of your life to accommodate for that. So you have disgruntled workers who are probably working slowly or more slowly statewide. You have their union that's seeking injunctions to overturn these decisions. You have a governor who's stealing, for lack of a better word, budgets from other departments that have nothing to do with him so he can balance his statewide budget because he lied to the people of California to get elected by telling them that we didn't need an increase in taxes. That we didn't need to triple the VLF so that all his friends could drive Hummers. In fact, he drives a Hummer, so that they didn't have to pay, the proper licensing fee on their $50,000 to $100,000 Hummer. Well, I submit to you the solution is to drive a cheaper car. If you can't afford the vehicle licensing fee, then you probably can't afford the car you're driving. So, because of that, things are very, very slow at the Workers' Compensation Appeals Board, and you may or may not be able to get your attorney to hurry your case through during this window that it may benefit you. So the bottom line is we may all have to sit tight. We may all have a lesson in civics to see how honest our government is, how honest our elected officials are, how honest judges are, point blank. Are they going to do the right thing according to the law? Are they going to reverse themselves because they were told to by a governor or for political expediency or to save their own jobs? We're going to find out if America is about truth or justice or if it's all about the dollar. Other national issues will continue to drive these changes and what happens specifically in workers' compensation in California. If we have national health care policy or universal health care policy, much of the costs that is driving workers' compensation rises in California are health care costs. Much of those costs will disappear, but it may be that President Obama will not be able to make changes in our health care system because we are still spending billions of dollars daily on President Bush's wars in Afghanistan and Iraq. And now we are trying to bail out the legacy of Ronald Reagan. President Ronald Reagan believed in deregulating everything and trusting business to take care of us. Well, you deregulated the airline industry, and they ran themselves into the ground and bankrupted on their pension programs in the last 2 years under the Bush Jr. administration. And we also had a situation where energy was deregulated, and that led to the Enron debacle, which, by the way, came from George Bush's friends in Texas and his donors, and was fostered in that spirit of make as much profit as you can. We're not going to watch over your shoulder. We trust you to take care of yourself. We are now bailing out the banking industry, which was deregulated, unfortunately, by a Democratic bill, at least with regard to lending to low-income people. But as we know, it's much bigger than that. The financial collapse has to do with insurance companies taking premium dollars for insurance policies that they never funded and that they spent and lost in the stock market. So President Obama may have his hands full spending money on all of those deregulated things, trying to fix them, thanks to President Reagan and his legacy, and the wars thanks to President Bush and his legacy. And there may be no money to fix healthcare in the United States. The other big problem we're going to have is, just as I've tried to tell you, the law is not about truth or justice or the American way. Workers' compensation in California is not about truth or justice, although it can be. It's often not. In the same way, healthcare reform is not going to be about truth or justice. Healthcare reform is probably going to be about how much money we have to spend, which we've already talked about. We may not have money to spend. But it's also going to be largely shaped and controlled by how much money insurance company lobbyists for the health insurance companies are willing to spend, how much money they're willing to put into re-election campaigns of senators, federal people in the House of Representatives, how much money they can spend to influence those votes. Because with term limits, which sounded like a good thing nationally and in California, with term limits, politicians most oftentimes are now running for their next office, and they can't build a power base to stay in power, so they're always running for the next election. And because of that, they're more beholden to money sources because they can't hold out and establish power to get beyond the influence of those money sources. So national politics, universal health care will affect California workers' compensation. It will affect the decisions in Almarez and Guzman, or at least how they play out in California. It could be possible for us to have a system in California where health insurance was covered and was taken out of the comp system by universal health, and then we would only have to worry about permanent disability, and injured workers could actually be paid fairly for their injuries and more completely than they are now, and prices or premiums would not go up in California. But that remains to be seen whether or not that will happen. I've seen where California Applicants Attorneys Association has issued a press release about the governor's efforts to influence, and his administration's efforts to influence judges and to influence the outcome of the Almarez and Guzman decisions. And I would submit to you that the most important thing injured workers could do, or people at home that care about injured workers could do, be to write to their state assembly person or their state senator and let them know that they now realize they were duped about the reform of workers' compensation in California. They now realize that the system is broken and needs to be fixed. But it's not broken and needs to be fixed in a way that helps insurance companies. It's broken and needs to be fixed in a meaningful way that will help injured workers in California and will at least get them some money for their injuries. And because that, you do not want to see the Almarez and Guzman decisions overturned, and that you know from the state's own study that these decisions will only increase workers' compensation costs 7%, which is not a huge increase given the fact that we just had a 24% increase before these decisions came out. So that's what individual workers, injured workers, and their loved ones, or anybody who cares about the politics of the system, can do immediately to counterbalance the governor's political influence and the administration's political influence that has been being exerted on the judges and the workers' compensation community. You can find all of these decisions on the state workers' compensation website at www.dir.ca.gov/WCAB, and then you want to go to enbanc decisions. You can go to Work Comp Central, which is a page on the internet with lots of forums where issues are discussed. Read that information with a grain of salt. It is a very defense-oriented website. Or Workers' Compensation Zone blog done by Julius Young with the Boxer firm in Oakland, California. Julius does a very good job of pointing out changes to workers' compensation and what's going on in workers' compensation on almost a daily basis. So you can read about those things and become informed and find out that the information you're being provided is correct, and don't let yourself be duped by a television actor and whatever influence his friends with money can help him put on the state of California. Thank you.